So it's Alison Colley here from Real Employment Law Advice, along with my colleagues Miranda and Albert. Say hi.
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 And we're going to be doing just a quick coffee chat about changing terms and conditions in employment contracts. And given the current situation that many businesses are finding themselves in, we thought that it would be useful to have a run through of this because we know it's one of the things that people are talking about and also asking us on a regular basis about, how can we change hours? How can we change pay? Can we make reductions? Can we change job roles? That sort of thing. So we thought we'd cover it off for you with a bit of information that hopefully you find helpful. So as I said, I covered off a bit there about some of the reasons why you might want to make those changes. But what are the other reasons why people might want to make those changes to the contracts, Albert?
Oh, well, hello, everyone. Well, there's lots of different reasons why an employer may want to be looking at changing your terms and conditions. Of course, in the current situation with the COVID-19 and the pandemic and the huge impact that's had on businesses, workload and staffing needs is a major reason why they might be looking at changing your terms and conditions. So the demand for the services or the goods that your employer provides. But there may be other reasons why. So, for example, if you've actually made a request for flexible working, perhaps, that might or would entail a change to your terms and conditions, or if a company is looking to perhaps move premises, that might be another more normal, should we say, reason why they might be looking at reasons to change your terms and conditions. But there's a whole range of potential reasons. As we go through today, the processes are perhaps relatively similar for whatever reason it is, but there will always be specifics that need to be discussed in that process.
Okay, thank you. That's great. And so, Miranda, if an employer wants to start making some changes to employee contracts, what's the first thing that they need to do?
The first thing to do is to have a look at the contracts to see whether the change that they want to make is addressed in the contract. So whether they actually need to go to the next step, which is obtaining employees' consent at all. So if it's a change that's anticipated very clearly in the employment contract, then they may be able to do it without any sort of formal process.
So what happens then if they don't have the ability to change it within the contract, or there isn't a provision in the contract? What's the next step that an employer would need to take?
Well, they will need to consult with the employees whose contracts they need to change in order to obtain their consent to whatever they want to do. That's the first step.
Yeah, and of course, obviously, the most important thing and the easiest way to make those changes is by agreement, isn't it? So if the employer wants to make a change, let's just say, for example, to working hours, as a result of changes in working practices brought about by, the requirements under the coronavirus risk assessments, they need to make changes to working hours. If they can get the employees to agree that, then of course that negates many of the problems that we may be talking about in a minute. So in terms of consultation, Albert, how would you recommend an employer starts that if they want to make some changes to contracts?
Well, throughout the whole process, the key is really going to be clear communication and honesty about the reasons why you're trying to do it. I would suggest that the first step in the process of trying to get your staff's agreement to a change to their terms and conditions would be a face-to-face talk. Obviously that might not be possible now, but perhaps an initial phone call to all of those staff, or just the one staff perhaps that are affected as a group, using technology or good old-fashioned telephone, to explain exactly why it's necessary. There isn't a process of consultation in the same sense as a as a redundancy situation might require, but it is all about communication. It's all about giving a reason why, giving them enough information so that employee knows what the change is going to mean to them, what impact it will have on their take-home pay or their home life, their family and work-life balance. That's the key, is getting that information across through good, clear communication.
Yeah, absolutely. And I think that if the more honest you can be, particularly in the current circumstances, the better. People will be more likely to be understanding about changes that need to be made now because of the world we're currently living in than they may have been beforehand. And it also stops people speculating about the reasons behind it and coming up with their own conclusions, which can then lead to disputes down the line. So if an employee agrees, then that's all very well and good. Obviously, if you've got a good relationship, good communication, and you can do that, then that's fine. But if an employee refuses to agree to the change, what are the steps you would need to take then, Miranda?
Well, there are a few options available to the employee. The employer could decide to serve the employee with notice to terminate their existing contract and offer re-engagement on new terms. Or it may be that the employer may decide that the change that they are seeking is so, if it was, for example, a change to their role, if that change is so significant, and the new role that they want the employee to do is so wildly different from what they're doing at the moment, then they may choose to put that employee at risk of redundancy. The other option, which is a more risky option, is to impose the changes and seek on the employees the fact that the employee continues to work for the employer, to seek to rely on that to imply that their implied consent to the change to their terms. So those are the options really available to the employer if an employee doesn't agree.
Yeah, and of course, in our advice would always be that terminating and offering re-engagement or imposing the terms should be sort of the last resort, if you like. And there may be other ways, including, consultation, mediation and discussion that might get you to that point. But if an employer gives notice to an employee to terminate their employment and offer them new terms, and they've been employed for more than 2 years, what's the risk to the employer there, Albert?
Well, the risk is that the decision to terminate the employment for reasons of refusing to accept those terms and conditions is an unfair dismissal. Obviously, they're offering re-engagement on the new terms, but there is still a dismissal and a termination of the old contract on the old terms. So the risk is that the employee would argue that it is unfair, that it's not a potentially fair reason for a dismissal. There is some confusion about whether that would necessarily amount to an unfair dismissal if they had gone through a formal consultation process, discussion, giving them the opportunity to talk about the change or alternatives to the change, some kind of negotiation, but the end result was still that termination. But the risk is still there that the employee would bring a claim for unfair dismissal, that their decision, the employer's decision to terminate and then offer re-engagement, was a breach of trust and confidence, a breach of the contract, and they pursue a claim for damages in the employment tribunal because of that. Plus, they may not, of course, accept the new terms, in which case you're left without an employee, without the staff to do the job that you wanted. And so, as you said, it should be a last resort, really, termination and then offering re-engagement, because probably the whole point that you're trying to change the terms is that you want to keep them in employment because you still have some job, some willingness for them to stay on, but you need to change it for some reason.
Yeah, absolutely. And what if the employee tried to claim redundancy, Miranda? So you've got a long-serving employee who's terminated and offered new terms, re-engaged on new terms. Could they seek to say that their position is redundant?
They could do, but I think the issue is that if you're offering them a re-engagement on new terms, albeit that they may be slightly, slightly to the employee's detriment, whether they're reducing pay or requiring them to do additional job duties, then that you as an employer could argue that you've offered them suitable alternative employment. And of course, if you've offered them suitable alternative employment, then the employee loses their right to a redundancy payment. Now, what's suitable is both objective and subjective. So it could be a tough argument for the employer to run, but nonetheless, it's worth exploring that as an option. If you do have somebody who says, well, hang on, what you're seeking, I've been here for 10 years, you're trying to change my job. I think I'm entitled to a statutory redundancy payment, and that could amount to quite a lot for an employer.
Absolutely. Yeah, and I suppose what the outcome of that is really, if you're at the point where you are terminating and re-engaging, that you should get some specific advice about the issue and the changes you're making. And one of the things that we've been asked, or I've certainly been asked several times, I don't know about you guys, but is by employers who are looking at making cutbacks. Well, can I change them to a 0-hour contract? Can't I just give them a 0-hour contract? That seems to be one of the major ones. So taking them from a guaranteed hours contract of perhaps 25 or 30 hours and saying I'm going to give you a 0 hours contract, thereby not having any guarantee of hours or pay. And so what are your views on that kind of change, enforcing that change? Albert, what do you think?
Well, it's not a change that I would advise anyone enforcing unilaterally without first seeking the agreement of their staff. But I do think it is actually a viable option, certainly for businesses in the current circumstance. I think it is an alternative to redundancy. It keeps that staff member employed. There aren't any guaranteed hours, of course, but they do have the flexibility to work elsewhere during that period. So the 0 hours can't be exclusive. And again, provided you contact the affected staff and explain to them why it is that you need to so drastically change their hours to go down onto this 0-hour contract. If you have that consultation, just as in a normal redundancy situation, if the employee has enough information to understand why you're doing it, and see that you're trying to keep them on the books, employed in a role for when work is available, then it is an option.
Yeah, but again, it's all about how you handle it, isn't it?
Yeah.
And often I think one of the things that we experience when advising employees is you have employers who maybe aren't very transparent and don't understand or empathise with what the employees are maybe going through, and then that causes them to have to get to loggerheads, if you like. Employees become, indignant about it, and then more difficult, and it ends up going down a route where you can't ever end up with an agreement. So yeah, absolutely. And I would go so far as, if you're a business owner and you're looking at making reductions and you need to make changes to contracts, it's just spelling out the financial position of the business. And if the changes are going to result in saving jobs, then telling staff this. If we all agree to work 4 days a week, then we can keep everybody employed. But if we don't, then we may have to make 3 of your colleagues redundant. So it's just being brutally honest. I think now more than ever, given the situation that the world is in. And so just before we wrap up, I just want to cover off about contract terms, because the other thing is to what extent can you include within the contract terms flexibility to make those changes in future? So can you, or would you advise including an unfettered right to make changes, and would that work? Miranda, do you want to take that one?
Well, the way the courts have interpreted that kind of clause is very, very restrictively. and you're not going to be able to rely on it to change to make changes to an employee's detriment. You know, the courts are very clear that if you want to build a clause in a contract which allows you flexibility to change things, it's got to be really, really specific. Otherwise, any ambiguity is just going to be construed against the employer who's seeking to rely on it. So, yeah, my advice is that's not to rely on that as your sort of fail-safe mechanism if you want to make changes in the future.
Yeah, absolutely. No, that's fantastic. Well, hopefully that gives employers some good insight into what they need to be thinking about in making changes. Is there anything else you want to add, or any tips you want to add in there, Albert, for employers? Someone at your door.
Someone at my door. I'm sorry about that. Well, in terms of drafting the contract, I mean, probably the most you're going to be able to get is perhaps a mobility clause. That's a pretty standard one, really. But as Miranda said, other than that, it's going to be very difficult for you to actually predict what might happen in 5 years' time if you need to make a change. If you're doing contracts now, perhaps there might be a bit more ability to predict perhaps what you might need to do. But top tip has got to be communication about why you're looking to make those changes. Otherwise, you're never going to get the agreement.
Absolutely. And what about you, Miranda? Any last thoughts on this you want to add?
Well, I had a thought about employers who are looking to do this for quite a number of employees, and it's really to do with, you know, thinking from the outset before you even consult with employees about what your end game is going to be if it's unlikely that the employees are going to agree to the change. So if you're seeking to change the contracts of more than 20 employees, and you need to be thinking, right, if I'm going to be looking at potentially dismissing them, terminating their current contract, which is effectively a dismissal, and offering them re-engagement on new terms, that triggers the collective consultation obligations. Where there are 20 or more employees, and so and that, of course, any breach of failure to collectively consult when you're obliged to triggers protective awards, which can be really quite financially problematic for employers.
Yeah, absolutely. No, that's a great point to raise, actually. So in terms of collective consultation, it means that, you know, engaging with employee representatives or trade union and having a minimum period of consultations. So certainly if that's the outcome that's, you know, potentially going to happen, if there isn't an agreement, then you should seek advice and get that process in place right at the outset. As you say, it can be fairly costly for employers who get it wrong. Absolutely. So, yeah, well, hopefully everyone's found that useful, a little rundown and a reminder about what happens if you need to make changes to contracts. And of course, if you want any advice or assistance from any of us, from Albert, Miranda or myself, then you can get in touch with us. All of our emails are at realemploymentlawadvice.co.uk, and we'll be happy to help you. So thanks very much for watching. Thanks, guys.